Hello everyone, a very warm welcome to this construction and engineering webinar brought to you by Birketts Solicitors. Thank you very much for joining us for this session. This is our autumn update for members of the Chartered Institution of Civil Engineering Surveyors. My name is Stefan Harris-Wright. I'm a partner at Birketts and I head up our construction and engineering team. Just a quick thank you to the CICES for inviting us to present to you for this session. Regular viewers amongst you will know that we've done quite a few of these over the years. We're always very happy to do so and grateful to be asked back as well. So just in terms of who I've got joining me for the session today, I've got three colleagues from across our construction dispute resolution practice. They are Sarah Evans, fellow partner based in our London office, James McLellan, he's an associate based in our Norwich premises, and also our colleague Rachel Lee, a solicitor from our Ipswich office. So just in case you haven't heard of Birketts before, hopefully some of you have, but there's some information for you at a glance up on this slide. I won't go through all of it, but just in sort of headline terms, we're a full service top 50 UK law firm. We've got 7 offices across the UK, in the east of England, London, the southeast, and also in Bristol. And as part of our organisation, we've got a specialist construction and engineering team who advise on both transactional, so non-contentious matters, project advisory, so live issues on construction matters, and also full-blown sort of dispute resolution services too. So briefly then, to summarise what it is we're going to be covering during the course of the session. As we've got the Women's Rugby World Cup going on at present, there's a bit of a rugby related theme throughout. So if you're not a rugby fan, then you'll have to bear with us. But the title theme for the session is At the Breakdown. So Sarah's going to talk about the do's and don'ts of terminating contracts. James is going to go through ideas around not dropping the ball. So this is relating to kind of practical points on the importance of preserving legal professional privilege and the consequences for parties if they don't do that properly. And then Rachel's going to wrap up those three with our traditional summary of interesting recent construction and engineering cases. And then we'll have time at the end for our usual panel Q&A. So just before we get into the sort of meat of the session, a few kind of housekeeping points from me. So there's an opportunity for you to put your questions to our panel through the questions function in the Teams portal at the top there. So please do, if you've got any burning questions, send them through and I'll do my best to get through those. We've also had a handful of questions in advance from delegates, which is great. Thank you for those. We'll get through as many of the questions as we can in the time available. If we can't get through all of them, or if there are, we sometimes get very sort of detailed, which is fine, sort of fact specific type questions. So if there's not time to get through all of those, then what we normally do is follow up with people afterwards. And then finally, the session is being recorded. So the colleagues at the CICES will circulate copies of the slides and the recording to you in the coming days after the session. So that's all from me by way of opening. So now if I can hand you over to Sarah to take it forward from here.
Thank you, Stefan, and thank you to everyone joining us in the UK and internationally today. As Stefan mentioned, I'm a partner in Birketts construction and engineering team in our London office, and my focus is on helping clients avoid disputes, and when they do get into a dispute situation, helping them to resolve them as effectively and cost efficiently as possible. So as we've mentioned today, with a nod to the start of the rugby season and the success of the England women's team, we're going to turn our attention to what happens when relationships between players in the construction industry break down. And I'm going to be looking at what are some of the key issues and some of the points that we should be wary of. I'm going to be focusing on that ultimate action of kicking a relationship into touch, of termination. And I'm going to be flagging some of the do's and the don'ts of the process. So first of all, it's important to remember that termination is an action of last resort. It's a nuclear action and it's a draconian act. And it's likely to cause anxiety and risk, whether you're the party terminating or you are on the other side as the party that's being terminated. It's rarely straightforward, and it's a tricky and risky process. And it's really important to get it right and to not end up on the wrong side of the referee's decision, whether that's an arbitrator, an adjudicator, or a judge. And quite often we received inquiries, it might be late on a Friday afternoon, where tensions are running high on a project and relationships are breaking down. And one party wants to do something to actually bring that termination, that relationship to an end. It's really important to get things right here. If you're the terminating party and you get the process wrong, you could yourself find that you move from being an innocent party to a party that's actually facing a claim for repudiatory breach. And if you're the employer, you could also end up being on the hook for a contractor's loss of profit on a project. And equally, if you're the party being terminated and you don't go about things in the right way, you could end up finding yourself in a much worse position that you actually need to be in. So I think it's fair to say that this is a really rife area for disputes. And the key is to trying to stay one step ahead and avoiding that dispute process. So how can we actually go about terminating? Well, there are only really limited ways of doing this. First of all, by agreement. Secondly, pursuant to the terms of the contract. And thirdly, at common law. So if we look at terminating by agreement first, this is termination on commercial grounds. Quite often this is recorded in a formal settlement agreement, and that minimises the scope for further dispute. This is the amicable divorce. This is the early conclusion, ending up with no arguments over procedural irregularities and no risk of the referee's whistle. Secondly, terminating pursuant to the terms of the contract. And I'm going to come on to this in a bit more detail in a minute. But so often parties negotiate, they agree and they execute and finalise the contract. And then that contract is just put away. It may be put in a hard copy file on a shelf. It may be put in an electronic copy somewhere on an electronic system. But this is the rule book. It's really important. This is how the parties are meant to play during the match, and it's really important that the rule book is followed, and every contract will be different. So if you find yourself in a termination position, it's really important to get that contract out, dust it off, read it from cover to cover, and work out what the rules are that you're meant to be playing by. And we often use the acronym RTC, read the contract. Some people put an adjective in there, RTC, but I don't want to get on the wrong side of the referee if they're listening on this by putting that adjective in. But it's really important. Follow that rule, look at the contract and understand it. And then finally, we can terminate at common law. Common law provides for the repudiation of a contract where there is a fundamental breach. And this is a breach going right to the root of the contract. But great care is needed if you're terminating on this way to get things right. So let's look a bit more closely at terminating pursuant to the rules of the contract. And again, the grounds here will depend on the precise wording of each contract. First of all, some contracts will provide for termination at will, and that means terminating the contract without having to give any reasons. It's important to note here that the JCT standard forms don't allow for termination at will unless the contract has been amended. And under NEC 4, termination will only apply if the employer or the client has chosen secondary option X11. So if you've got these grounds in your contract, the provisions take effect quickly. They limit the sums that the terminated party can recover. They're really useful for employers, but they are not so useful for contractors and subcontractors. So if you're a contractor or subcontractor facing this clause at the outset, when you come to negotiating that contract, it's advisable to try and get that provision booted out, or if you can't get it booted out, try and get the longest notice period possible inserted in the contract, because that will give you some time to prepare. That will give you some certainty over moving on to another project and actually being able to manage the financial consequences. If we look at the two middle grounds here on this slide, this is termination for breach. And turning first to terminating by the employer for contractor default, it's worth noting here that we're not talking about terminating the contract completely. We're talking about terminating the employment of the contractor under the contract. So what that means is that even if there's termination, there will be parts of that contract that still have life, that still carry on after termination has taken place. So in what circumstances might there be grounds for terminating the contractor's employment? Well, first of all, if the contractor suspends without cause or abandons the works. Secondly, where there is a lack of progress, and here we usually mean a failure to proceed regularly and diligently, or a failure to proceed without due diligence. And I'm going to come back to this one in a bit more detail in a moment. There can be also a ground for termination where there is a contractor refusal to comply with an instruction to remove works, where goods are not in accordance with the contract, or there is a contractor failure to remedy defects. And other circumstances include a contractor not complying with CDM regulations or failing to provide security where there's an obligation to do so. But again, it's going to be contract specific in terms of the grounds here. And then if we look at it from the other side, termination by a contractor for employer default, well, the sort of circumstances here that can give right to a grounds for termination include the employer failing to pay by the final date for payment, if the employer interferes with the issue of a certificate, or where, again, the employee doesn't comply with CDM regulations, or if the works are suspended for a specified continuous period due to an architect or contract administrator's instruction or an employer's act of prevention. And finally, under the contract, there are quite often provisions which enable either party to terminate for specific events. And these include insolvency, force majeure, and civil commotion or terrorism. And just popping back to that ground of insolvency, again, there will be a definition in particular contracts as to what constitutes insolvency. But we can't really look at those provisions in isolation. During COVID, we had the Corporate Insolvency and Governance Act 2020 land on the scene to give some protection during the COVID period, but some of those provisions have hung around afterwards. In terms of employer's position, well, the employer's position is largely unaffected, but the Act does make changes to the Insolvency Act, meaning that contractors and subcontractors can find that even though they may have a contractual right to terminate for insolvency, in practice, they're not allowed by SEGA to do it, because to terminate in that way for upstream insolvency would have the result of collapsing the whole supply chain. And that's something SEGA stepped in to outlaw. So worth being aware of that. And finally, if you do find yourself in a position where you've established a ground for termination, it's really important not to do anything to lose that ground. Don't do anything to accept the breach or to accept it or to affirm that breach. because otherwise you could end up in a position of facing the referee's whistle and have to go all the way through the process again to establish your ground for termination. So let's just come back to one of those grounds I mentioned, which is the employer being able to terminate for contractor default in circumstances where the contractor has failed to proceed regularly and diligently with the works. Now, this provision is included in both, moved too quickly there. This provision is included in both the JCT standard building contract and the JCT design and build contract. But it is a really hotly contested area, and unhelpfully, the contract doesn't provide any definition here of what this means. The courts had a go at trying to establish a meaning for this, and it came up with an ability to proceed continuously, industriously and efficiently with appropriate physical resources so as to progress the work steadily towards completion, substantially in accordance with the contractual requirements as to time, sequence, and quality of work. A really snappy and helpful definition there. And that was the court in the case of West Faulkner and London Borough of Newham. So I'm not sure that takes us any further to understanding what that means. Any guesses as to how the court tried to go on and make that a little bit clearer? Well, it concluded that it was actually an impossible task. It's a bit like an elephant. You know it when you see it. So it's going to be very fact specific and depending on the facts of each individual situation. What the court said is that a contractor being in delay alone is not going to be enough to get an employer home on this point, but it may call for further investigation. It may help if the employer has evidence of a failure to achieve program productivity or a failure to properly resource. But this is going to boil down to what records does the employer have to prove this. So records is going to be the key to trying to establish a termination on this ground. And don't forget, the referee's interpretation of the law on this point may differ very differently to what you think the interpretation is. So moving on to, once we've established the ground, how do you actually go about doing it? Well, it's really important here to follow the contractual procedure that's set out to the letter. If the contract tells you to serve a notice on pink paper, hopping on one leg, it's really important to do it. You need to do it precisely to the requirements. And we need to be looking out for a number of notice provisions here and what the contract says. First of all, looking at the form of the notice. For termination, a contract will often have a completely separate process for the form of the notice to just general notice provisions. So check the contract, but quite often it usually prescribes for that notice to be in writing. In terms of the content of the notice, we usually advise that you should put on top of the notice that it should be clearly marked as a termination notice, and quote the contract clause or the ground that you're relying on. In terms of the timing of the notice, that's going to be defined by the contract. We may have a two-stage process here, a first default or hurry up notice, and a second, which is actually served after a prescribed period of time where the default hasn't been rectified. In terms of who serves the notice, well, again, contracts vary. The JCT standard building contract provides for the architect or the contract administrator to serve the first hurry up notice, with the employer serving the second. In the case of the design and build, the employer or the employer's agent serves both. And again, how is the notice served? Don't assume in this scenario of us being commonly using email on a day-to-day basis that the contract will allow you to do it. It usually doesn't. The JCT contracts prescribe for service by post or by signed for or special delivery post. And it's really important to serve it on the address and on the people that are prescribed in the contract. So we've looked at the what and how, but what are the main do's and don'ts to avoid getting injured? Well, first of all, don't ignore the alternatives to termination. As we've said, it's a really risky process. So there may be other alternatives that are available or better ways of doing it. For contractor default, an employer may be able to suspend instead. And if there are delay in performance issues, then the employer should consider whether it can levy liquidated damages or performance damages. Or is there any other available security it could call on to protect its position? In the case of a contractor, it may find that it's actually able and easier to adjudicate for the employer's failure to make payment. Do consider the consequences of termination before doing it. So again, it's really important to look ahead. For a terminating employer, it needs to think about how it's going to get the works finished and whether it needs any outstanding information to do that. So if it does, ask for those before actually carrying out termination. And in the case of a contractor who's being terminated, it needs to think ahead and think about it protecting its financial position. Do prepare well. Do collate the evidence. Those records are really important before you actually terminate, and it's really important as well in cases of dispute to hang on to those records after termination itself. Do follow the contractual procedure to the letter, and as I've said, don't lose the right to terminate by affirming any breach. Don't do anything to accept it, and don't dawdle. And above all, if you find yourself in a termination provision, it's really important to take legal advice at the outset. You're going to say, of course, I'd say that, but it's really important to get that process right to ensure you end up on exactly where you want to be in a termination situation, and that you end up getting clapped off the pitch by your enthusiastic supporters at the end. So thanks for listening to me on that part. I'm now going to hand over to James, who will look at another area we need to be wary of when we're in a dispute situation, and that is the area of privilege.
Thanks very much, Sarah, and thank you everyone for joining. As mentioned, my name's James McLellan, and today I'll be providing a practical guide to legal professional privilege. Now, the obvious place to start is with an explanation of what privilege is. Privilege provides a legal right to withhold evidence from inspection by a third party or a court. In layman's terms, this means that you can avoid providing evidence, particularly adverse evidence, to a court, tribunal, or adjudicator. In practice, where a relationship breaks down and privilege is used properly, it can be key in ensuring a secure environment for discussion, the formulation of positions, and obtaining advice from the outset. Now, legal professional privilege, the subject of this talk, is a particular form of privilege. You may have heard of other kinds of privilege, such as without prejudice privilege and common interest privilege. However, legal professional privilege relates to communications in respect of parties' legal positions and legal disputes. Now, there are two forms of legal professional privilege which can arise simultaneously but are distinct: legal advice privilege and litigation privilege. You will see the requirements for both these forms of privilege outlined on the accompanying slide, and I'll just run through them quickly now. So, starting with legal advice privilege, the first requirement or feature is that the communication needs to be confidential. This is generally a fact-specific question based on the availability and the nature of the communication. So, for example, certain financial information could be highly confidential in the context of negotiations over a potential merger, but is less likely to be so where it has been published and is available in, say, a company's yearly accounts. Second requirement, that the communication be between a lawyer and their client. Now, the requirements for what constitutes a lawyer are quite loose and cover individuals qualified in, say, England and Wales as solicitors, barristers, or qualified legal executives. The requirements for what constitutes a client, by contrast, are very strict, and it's in practice limited to those individuals actually charged with instructing the relevant lawyers. This is known as a client team, and it's a substantial issue which we will return to during this presentation. So the third requirement for legal advice privilege is that the communication be for the purposes of giving or receiving legal advice. So the communication must come into existence for this purpose. For example, a request for advice would be privileged, but potentially historic background documents may not be. Now, moving on to litigation privilege, you'll see the first requirement again for litigation privilege is that the communication be confidential, much like legal advice privilege. The second requirement, however, is a substantial difference, point of difference between the two forms of legal professional privilege, in that litigation privilege applies to communications between a lawyer, client, or third party. So litigation privilege can apply in respect of communications with third parties, and you're not limited solely to communications between a lawyer and the client team. And the third requirement, that the communication be produced for the dominant purpose of litigation, which is pending, reasonably contemplated, or existing. Now, just breaking a few of these points up, the question of dominant purpose is to be considered based on the state of mind of the commissioner of the communication. So in practice, that's usually the client. The need for a dominant purpose means that a document will not benefit from litigation privilege where there are, say, two competing and equally important purposes. And as to the requirement for litigation that is pending, reasonably contemplated, or existing, pending and reasonably contemplated do not require that the chance of litigation in future be more than 50%. A good way of conceptualizing this requirement is that litigation may happen in the future. So in terms of takeaways, we have two forms of legal professional privilege. These can arise simultaneously, but in practice, legal advice privilege generally arises slightly earlier in a matter, given that litigation privilege requires at least the prospect of litigation. Now, we understand the nature of privilege. Let's consider the nature of the threats parties should be wary of, i.e., the circumstances where parties can be expected to produce documents for inspection. Now, in construction disputes, the three most likely fora in which document inspection may be required are adjudication, litigation, and arbitration. Dealing with these in turn, while adjudication does not have a formal disclosure process, adjudicators are empowered to order production of relevant documents where required. In litigation, parties are expected to disclose with their initial statements of case those documents that they rely upon or that are needed to understand their position. After that stage, a process of extended disclosure can be chosen from 5 available models, and this decision is usually made on the basis of proportionality to the sums and issues in dispute. In respect of arbitration, arbitration is a consensual process, so it's dependent on and determined by the agreement of the parties. Parties can agree on institutional rules and the disclosure regime they wish to apply, but a tribunal usually retains a discretion to determine the particularities of the process and to order production of documents. In practice, the way this works is that parties are generally expected to produce those documents they rely upon and are able to request documents from the counterparty where relevant and material to the points in dispute. I would note, however, that disclosure and inspection requirements aren't limited to formal disputes. Parties can be ordered to produce documents in the context of investigations by, say, the police or tax and regulatory authorities. And so privilege can provide protection outside a formal dispute setting as well. So key takeaways on disclosure obligations. Parties do have obligations to disclose potentially adverse documents within and outside of formal dispute settings. However, when used properly, privilege can substantially reduce the extent of the risk arising from these obligations and help put parties on the front foot from the outset of say, a relationship breakdown. Now, the rules surrounding privilege can feel very abstract, and so it helps to provide a practical example. In this case, we have an employer, Twickenham Limited, which is dissatisfied with its contractor, Harlequin Construction, and has requested advice on its position. The process of obtaining that advice engages issues of legal professional privilege and requires information sharing at multiple stages, as listed on the slide. We will consider some of the errors parties can make in this kind of process and examples of best practice shortly. But first, we need to ask which form of legal professional privilege do we think applies here? Now, this is something of an impossible question, given that the answer depends to an extent on Twickenham's own understanding of its position. Does it consider litigation to be pending, reasonably contemplated, or existing? And is any such litigation the dominant purpose of the advice requested? Now, for the purpose of this presentation, I'm minded to say no, that Twickenham's request for advice relates to liability under the contract and doesn't hint at future litigation, and as such will consider the fact pattern from the perspective of legal advice privilege. So let's look again at that list of actions and consider where our claim to legal advice privilege could fall down. Here we have an initial briefing to lawyers, which is fundamentally fine, but I would note that Twickenham's legal team has instructed lawyers here, and as such will be the client team for the purposes of legal advice privilege. Then we have the provision of relevant documents by commercial colleagues. Client teams often refer us to commercial colleagues for background factual information. In respect of legal advice privilege, this is problematic where we have been initially instructed by legal counsel, as the commercial team will then generally fall outside the client team. It's also worth noting the reference there to historic documents. Parties need to be aware that historic documents do not automatically benefit from privilege simply because they are sent to lawyers. Next, we have the receipt of the advice and initial consideration. Here, the advice has been sent to the legal team, the client team for the purposes of legal advice privilege, but it's then been circulated onwards and considered at a board meeting. Parties should be aware of and keep track of where the content of advice ends up. In this example, board meetings are recorded in minutes, which cannot be privileged. And so, depending on the content of those minutes, a degree of the advice provided may be recorded in a non-privileged document. You'll see that in this example, the client has also engaged a consultant. Parties, we find, often involve external agents in their instruction of lawyers, and agents can convey privileged communication, but only where they provide a medium of communication only and do not have personal input. It's therefore somewhat questionable whether there is much practical benefit in involving an agent in these circumstances. Thereafter, Twickenham has requested further advice on the commercial impact of the advice provided. This is quite common. However, the dominant purpose test referred to earlier has to be borne in mind. Where advice ceases to focus on the client's legal position, and an external lawyer instead acts as a broader commercial advisor, such communications can cease to be privileged. And a final point on knowledge share and financial reporting. Parties should be aware of the use of advice documents going forwards and consider, is a document uploaded anywhere that might result in it no longer being deemed confidential and therefore privileged? And is the content of advice incorporated into any documents which might be publicly available and therefore not privileged? So what principles can we adopt to ensure we maximize the likelihood of privilege attaching? It's helpful to group these according to the requirements for privilege. So starting with confidentiality, it is fundamentally important to control the spread of documents and information. This can be via information barriers or more generally avoiding repeating advice. Where advice does need to be repeated and circulated, it is possible to provide an expressly limited waiver of privilege, which provides that privilege will be maintained generally against other parties. In respect of lawyer and client communications, discussions with legal advisors around privilege should take place early, as damage to a party's position can be done from the outset when a relationship is deteriorating and privilege is not borne in mind. We can help in this regard by assisting in establishing a client team, circulating documents on our client's behalf, or reviewing internal processes to ensure privilege protections are maximized. And on dominant purpose, when corresponding, it's important for parties to always think whether there is a clear dominant purpose to the communications before preparing them. It's best to avoid blurring boundaries where possible. So to the extent possible, limit communications which deal with both legal issues and the financial impact or broader commercial concerns. And if the potential for litigation arises, this should be recorded in writing as a reference point for the future, which can be used to pinpoint where litigation privilege can be relied upon. And finally, while it's not determinative, it is always advisable to clearly mark potentially privileged documents and correspondence as such, as a point of good document management and organization. Now, we have reached the end of this discussion, which is intended as a broad and practical overview of privilege. I will now hand over to my colleague Rachel, who will give an overview of case law relevant to the issues of termination and privilege. Thank you.
Thank you, James, and hello, everyone. As mentioned, my name is Rachel Lee, and I'm a solicitor in the construction team at Birketts, based in Ipswich. Today, I'm going to be discussing some cases relevant to both the themes of termination and privilege. So beginning with the termination cases then, the first I'm going to be discussing is Optimus Build Limited and Southall. In this case, the TCC dealt with a pretty familiar scenario, a breakdown between a contractor and employer mid-project, with both sides claiming that the other had committed a repudiatory breach. Now, Optimus was engaged to carry out extensive works on a residential property. The contract was informal, so there wasn't any signed JCT or bespoke agreement. Instead, the contract was based on a series of meetings and emails. Optimus believed it was a fixed price contract, whereas the homeowners thought that it was cost plus. So the dispute kicked off after Optimus submitted its third interim valuation. The homeowners queried the figures and demanded a breakdown. A site meeting followed, which inevitably became quite heated, and Optimus then suspended the works and proposed a meeting to resolve the payment dispute. The homeowners saw this as a threat of, to quote, holding a gun to their heads, and responded by telling Optimus to remove its equipment and that they'd be making alternative arrangements. So each side accused the other of repudiation. Optimus said that the homeowners had thrown them off the site, and the homeowners said that Optimus had walked away first. Optimus then issued a Part 7 claim in the TCC seeking damages for breach of contract and loss of profit. The court were tasked with deciding what was the contractual basis. Was it fixed price or cost plus? And who committed the repudiatory breach? So in terms of the contractual basis question, the judge found that the contract was fixed price, not cost plus. It was found that the employer's acceptance of Optimus's budget estimate gave rise to a lump sum pricing structure. The estimate had been provided in response to a request for a lump sum quotation and referred to price, not estimated costs, and there wasn't any reference to markup or overhead profit. As for who committed the repudiatory breach, the court found that Optimus's suspension of works was not repudiatory, it was conditional and aimed at resolving the dispute. In fact, the homeowner's actions of seeking alternative contractors and demanding removal of scaffolding amounted to repudiation, which Optimus validly accepted. So Optimus was awarded the balance of the contract price and loss of profit on the remaining works. In coming to its decision, the court applied the test for repudiatory breach, which is whether the conduct showed an intention not to be bound by the contract. The judge emphasised that a contractor pausing works due to non-payment is not automatically a repudiation. The homeowner's reaction was considered to be disproportionate and amounted to premature termination, and the contractor's conduct must be assessed in context. So here, Optimus had made efforts to resolve the dispute and resume works. In terms of some key takeaways of the case then, repudiation is a serious allegation and it must clearly show an intention not to perform. Termination for repudiation is very high risk, a bit like a drop goal from halfway a la World Cup final 2003. Miss and you may well lose the match. Suspending works for non-payment can be valid, but it must be clear and proportionate. Jumping the gun on termination can backfire and you might end up being the one that's in breach. So it's very important to always check the contract before suspending or terminating, as justification will be key. And communication counts. A well-worded email could be the difference between repudiation and resolution. So now looking at the case of Manor Co-Living and RY Construction, this is a case that further highlights the risks of going for a try without checking that you're still in play. So this dispute arose under a JCT Design and Build contract 2016. RY Construction was appointed to convert a former office building into residential accommodation. Manor Co-Living, the employer, became frustrated with delays and alleged poor performance and decided to terminate the contract, not under the JCT's termination provisions, but by alleging repudiatory breach at common law. In the round of adjudication that followed, the adjudicator found that RY Construction had not repudiated the contract, that Manor's termination was wrongful, and RY was entitled to damages for breach. Manor didn't accept the adjudicator's decision, so issued a Part 8 claim in the TCC seeking declaratory relief that its termination was valid and that RY had been in repudiatory breach. RY responded with a counterclaim for damages. So in the TCC proceedings, the court found that RY Construction hadn't abandoned the site. Instead, the court found that RY had paused works due to Manor's failure to make timely payments under the contract. Specifically, Manor had failed to pay certified sums, which left RY without the cash flow needed to continue works. And this was deemed to be not as a refusal to perform, but a commercially justified suspension. So a response to breach, not a breach itself. The judge noted that RY had made efforts to engage with Manor and resume works once payment issues were resolved, and there was no evidence of an intention to abandon the project or walk away from contractual obligations. And very importantly, Manor's termination letter did not comply with the JCT contract provisions, and its attempts to terminate at common law was deemed to be unjustified. The court found that Manor had failed to establish that RY's conduct amounted to a repudiatory breach. Instead, Manor's actions, terminating without proper basis and failing to follow the contract's termination procedure, amounted to a repudiatory breach, which RY validly accepted. So RY was awarded damages for loss of profit and cost incurred, which resulted in a costly own goal for Manor. So in terms of some key takeaways of the case, in the decision, the judge emphasised that termination at common law is a drastic remedy and must be based on clear evidence of a serious breach and not caused by your own conduct. Courts are going to be looking at the full context, including reasons for delay or suspension. And it's also vital to always check whether the contract provides a termination route and stick to it. Contractual termination provisions must be followed, especially under standard forms like the JCT, as skipping them can invalidate your termination. And if you go rogue, you risk being penalised for a high tackle. So I'm now going to turn to the theme of privilege. And the first case I'm going to be discussing is Three Rivers DC and Bank of England No. 5, also known as the Three Rivers No. 5 case, a landmark decision that continues to shape how we understand legal advice privilege. So this case arose out of the collapse of BCCI and the subsequent Bingham inquiry. The Bank of England appointed a small internal team, the Bingham Inquiry Unit, to liaise with its lawyers and prepare submissions. The bank claimed legal advice privilege over a wide range of internal documents prepared by employees and ex-employees, arguing that they were created for the purpose of obtaining legal advice. In its decision, the Court of Appeal took a restrictive view, and it held that legal advice privilege only protects communications between a lawyer and their client, and that in a corporate context, the client isn't the company as a whole, but rather a narrow group of individuals who are specifically tasked with seeking and receiving legal advice. Communications from other employees, even if they were used to inform legal advice, were not privileged. So this decision has had significant practical consequences and means that internal documents prepared by employees, even if they're intended to support legal advice, may be disclosable unless the employee is part of the designated client group. It doesn't extend to communications with third parties or internal documents prepared by employees outside the designated client group. And just to point out a quick distinction, there's also another case, which is the Three Rivers No. 6 case, which went to the House of Lords at the time. And No. 6 focused on what types of documents are privileged and confirmed that lawyers' internal working papers may be privileged even if they haven't been shared with the client. So back to the Three Rivers No. 5 case, since then, the courts have heavily criticised this approach. In Director of the Serious Fraud Office and Eurasian Natural Resources Corporation, the Court of Appeal made it clear that if it had been open to them to depart from the Three Rivers No. 5 case, then they would have been in favour of doing so. However, this is a matter that would have to be considered again by the Supreme Court. Similarly, in Civil Aviation Authority and Jet 2, the Court of Appeal considered the foundation of the judgment in Three Rivers No. 5, which was an analysis of 19th century authorities, and considered that it was unsafe because those cases were decided at a time when the distinction between litigation privilege and legal advice privilege was very much in its infancy. The court added that the difficulty with Three Rivers No. 5 was that it did not recognise that in the present age, companies can be extremely vast and multinational, and that information on which legal advice is sought may well not only be in the hands of instructing lawyers. So it's possible that the Supreme Court may revisit this case again in the future, but for now, it's best to play it safe, define your client group early, and the control of circulation of information. So in terms of some key takeaways of the case narrowed the definition of client for legal advice privilege. Not every player on the pitch is protected. Clients should carefully consider who is authorised to seek legal advice and document this clearly, ideally at the outset of a transaction or investigation. And likewise consider creating a record that can be updated as matters progress of who constitutes the client for privilege purposes, however be mindful of the risk of waiving the privilege. And the case isn't without controversy. The Court of Appeal has strongly criticised the decision in later cases and made clear it would have departed from the decision if it could. So communications from employees outside the client group may be disclosable unless covered by litigation privilege, which in comparison can offer broader protection, but only if the dominant purpose is litigation. So it's important to channel legal advice through the designated client group or in-house legal team, but to be cautious about assuming that privilege applies to all internal communications. Finally, I'm going to be discussing the Jardine Strategic Holdings and Oasis Investments case. This is a recent landmark decision from the Judicial Committee of the Privy Council, the JCPC, that has reshaped the law on legal advice privilege in shareholder disputes. So this case arose from a corporate restructuring within the Jardine Matheson Group. In 2021, Jardine Strategic Holdings was amalgamated with JMH Bermuda Limited. Minority shareholders who were unhappy with the offered price of $33 per share brought appraisal proceedings under Bermuda's Companies Act, seeking a judicial determination of fair value. As part of those proceedings, the shareholders sought disclosure of legal advice obtained by the company before the amalgamation, and they relied on the shareholder rule, which is a long-standing principle that allowed shareholders to access privileged legal advice paid for out of company funds unless the litigation was hostile. So the key legal issue to be decided here was, could the company assert legal advice privilege against its own shareholders in litigation, or did the shareholder rule override that protection? So the JCPC, in its decision, abolished the shareholder rule, and it held that the idea that shareholders have a proprietary interest in company assets, including legal advice, is outdated and inconsistent with modern company law, and that there's no sufficient joint interest between company and shareholder to justify overriding privilege, and that legal advice must remain confidential to ensure directors and management can act in the company's best interests. In a rather memorable line, the JCPC said that, like the emperor wearing no clothes in the folk tale, it is time to recognise and declare that the shareholder rule is altogether unclothed. So as a result of this case, companies can now assert legal advice privilege against shareholders in litigation, even if the advice was obtained before the dispute arose, and reinforces the principle that legal advice is for the company, not its shareholders. And just finally, for some context, the JCPC is the final appellate court for many overseas territories, and normally its decisions wouldn't be binding on English courts. However, in this case, the JCPC issued what is known as a Willers and Joyce direction, stating that its decision should be treated as binding by courts in England and Wales. So the ruling will change English law, and the shareholder rule is no more. So this is a major win for corporate confidentiality and offers clarity in privilege law, which is now playing a tighter, more disciplined game as a result. And that's all from me. Thank you very much. That will bring us on to the Q&A section of the webinar.
Great stuff. Thank you, Rachel, and thank you to James and Sarah as well. We've got just over 5 minutes left before the advertised finish time to cover off some questions. So we've had a couple of questions in during the course of the session. So perhaps if I launch into those first. James, there's quite a heavy focus on privilege in the questions coming in. So I'll come to you first if that's okay, and then maybe
Sure.
And go around the panel if anyone else has any thoughts. But delegates, you can see the questions that have come in. We've had a question in from Stephen, who's an expert witness, question about contrasting approaches between UK privilege rules and those he's experienced elsewhere on projects he's worked on in the USA and parts of Australia. But James, what were your thoughts on that?
Yeah. So I think the question kind of focused on the benefits and sort of disadvantages of other of the English and Welsh system against others. Now, I can't speak in detail as to the particularities of US or Australian disclosure and inspection systems, but in terms of the benefits of the UK approach, I mean, privilege is one of those areas where lawyers can start to use lots of exciting terms around, civil liberties and things, because it is fundamentally, that's ultimately where it arises from. It's a fundamental right to obtain advice and input on legal issues, and that ultimately does provide a degree of security to parties to be able to formulate their positions and obtain accurate and realistic advice based on all the facts, kind of a warts and all picture of their position, which allows them to progress any matters in a realistic way. I do accept, though, that it can, where you have significant privilege protections in respect to communications with, say, an expert, that can prevent information sharing between both parties. So, you know, there may be less scope for the issues in a party's position on the facts being circulated to the other side. But considering a sort of wider disclosure approach, as I say, I don't know exactly how it operates elsewhere. I can see how, you know, if you had more expert correspondence that could be disclosed, that might be helpful in sharing position and sharing positions. But there's also questions as to how that fundamentally works in practice, if it does encourage parties to, when liaising with their experts, avoid putting things in writing. There's also, I suppose, questions as to how this information might be disclosed in practice if parties aren't necessarily aware of the existence of, they might not be aware of the existence of expert communications. But yeah, the international aspect's definitely an interesting one to raise, and it varies significantly. I mean, you've got you only mentioned common law jurisdictions, but if you go to civil law jurisdictions, they have a completely different inquisitorial system. In, say, for example, in lots of countries in the Middle East, they don't even have a consistently applied principle of legal privilege. So yeah, it varies substantially. I accept there's downsides to the English and Welsh system, which I can, but I'm not too well qualified to speak on Australian or American law.
Great, thanks, James. Sarah, I don't know if there's anything you wanted to add to that based on your experience.
I think all I would say is, from our perspective over here, I mean, the experts under the CPR rules owe a duty to the court, and when they actually get to exchange and provide their reports, they have to attach the instructions that they had to that. I can see why those communications may take place. You know, let's have a quick chat before you actually put pen to paper. I think the only thing I would say there from experience is sometimes when experts are in the box, they may be asked some tricky questions. And if the other side's barrister got wind of this, they may ask some difficult questions like, was there ever any influence? Did you ever have any chats? Did you change your opinion before you actually produced a report? And I think if under oath they came out and said, yeah, we had some conversations before, I can see a clever barrister on their feet using that to undermine the credibility of an expert witness. So I think that's the only thing from experience I would say from our side.
Great, thanks, Sarah. I'll squeeze in two other questions, one live from the floor and another one which came in slightly in advance. So Rachel, if I come to you, question on termination, which is, can a party rely on common law termination if the contract provides for a contractual termination mechanism?
I would generally say no. The courts are going to expect parties to be following termination provisions that are set out in the contract before resorting to your common law rights. So standard forms like the JCT or NEC will include the detailed procedures for termination, including notice requirements, etc. And if a party bypasses these and attempts to terminate at common law, they're going to risk invalidating the termination and being found in breach themselves. So in the Manor case that I discussed, Manor there ignored their JCT termination procedure essentially, and their letter didn't comply with the right provisions, and they tried to rely on the common law termination provisions instead, and the court basically rinsed them for this, and they wouldn't even consider if there was a common law repudiation claim, really, because they'd sort of fallen at the first hurdle by not complying with the JCT properly. So takeaway really is common law termination isn't a shortcut, it's a last resort, and it'll only be valid if the contractual route is unavailable or inappropriate in the set of circumstances.
Great, thank you, Rach. Last one, if we go to the question that came in during the session from Jacob, thank you for that. So 2 parts to this. James, if I come to you first. So first bit, can people be added to the client team or group after the initial instruction? And secondly, are you able to give an example of when a third party can be protected by litigation privilege?
Sure. So yes, to the first question, you can amend a client team, but there's a limit which will depend on the kind of facts of each case. So you taking an extreme example, you might struggle to add someone, say, to a client team for a single meeting in order to obtain their input and then remove them from the client team afterwards. The courts will probably you'll get quite short shrift if you're found to artificially play with the boundaries of the client team. But if it's a genuine realistic amendment of the client team, which can be which just makes sense for practical purposes, yes, you can change the client team. And then the second point was an example of when a third party will be protected by litigation privilege. I suppose the core one that comes up will be expert input. So if you think about that, even at the pre-action stage or before a kind of formal expert appointment, if you're obtaining less more informal input from an expert, but litigation is coming down the line subject to kind of the broader position around CPR rules, there are circumstances in which that kind of involvement could benefit from litigation privilege. Again, it's a very fact-specific area, but that's the one that kind of springs to mind immediately for me. I don't know, Sarah, if you can think of any others.
I think sometimes you may have a consultant who's actually outside the client organisation, not an employee, but they've been involved. And again, I mean, it still needs to be for the dominant purpose of the litigation, what they're doing. So I think any sort of consultant, and sometimes, again, fact specific, but clients will have other advisors that are helping them outside their organisation, and they may just want to bring them into the fold on that for the litigation.
Great stuff. All right, thanks everybody. I'm going to draw things to a close there, just as we're up slightly past our time of 1:30. But thanks very much, Sarah, James, Rachel, for joining us for the session. Thank you everyone for attending. I hope you found it informative, useful. Hopefully got a few nuggets in there to carry forward for things you're working on day to day. The recording of the session and the notes, as I mentioned, will come through to you from the CICES in the coming days. And then looking ahead, our next session is in our diaries for the 2nd of December. So look out for more information on that from the CICES again. But all that remains for us to say is thank you again for joining us and enjoy the rest of your day.